Hello, I'm Jack Gately from Jack Gately Real Estate and from the All Online Real Estate Academy. Here's a quick overview of the so-called lead paint paperwork that you're going to be doing as a real estate agent here in Massachusetts. So there's actually three different sets of lead paint so-called paperwork. One is for the sale of a property, another is for a rental, and the third is for a vacation rental, less than 31 days. So let's take a quick look at the front page of the 11-page package that is used when you sell a property. Now, I want to just emphasize that word package because this is something that a lot of agents use only the last page. They only use the page 11 of the document, but as you can see here, and we'll highlight for you, this package must be given in full to meet state and federal requirements. It may be copied as long as the type size is not made smaller. So what you definitely see out there in practice is agents just using the last page. You really should include the entire package as the disclosure to the buyer. When do you need to do this? Just a quick reminder, it must be done before the purchase and sale. So in some markets in Massachusetts, that means it's actually uploaded to the multiple listing service as an attachment or a document to the actual listing. But if you don't do it that way in your area or at your agency, my strong recommendation to you would be to make sure that this is sent over to the buyer's agent as soon as an offer is accepted. In fact, in my practice, what I do, if I don't have it uploaded to the MLS, which I do think is perhaps a better option, but if you don't do it that way, when I send over the offer as accepted, I include the lead paint paperwork, so-called, at that time. So just a quick reminder, you've got to get it done absolutely positively before the purchase and sale is signed. So another reminder here, real estate agents must also tell prospective purchasers that under the state law, a new owner of a home built before 1978 in which a child under 6 will live or continue to live must have it either de-leaded or brought under interim control within 90 days. So effectively, it is the buyer who's responsible for de-leading within 90 days of taking title if they're going to have a child under 6 living at the property. You know, down here a little bit further is a really good reminder, if you weren't already thoroughly convinced, of why you might want to spend some extra effort on getting this done the right way. First off, you might be reminded that under state law, there's a possible $1,000 penalty. Let me assure you that is the least of your worries. There's a civil penalty under federal law up to $10,000, plus under federal law, possible criminal sanction. In addition, you could also be sued under the Massachusetts Consumer Protection Act, commonly known as Chapter 93A, which allows for up to triple damages against deceptive and unfair business practices here in Massachusetts. So definitely something that there's a significant deterrence effect out there, reminding you to do the right thing. Big statement here at the bottom of page 1. Please take the time to read this document. And then this part really should be rather stunning. Lead poisoning is the nation's leading environmental hazard affecting children. Don't gamble with your child's future. Or, I should add, the future of your clients' children or the future of your co-brokers, the child of your co-broker. This is a really serious issue. I just can't really stress that more than enough. There's a lot of bad things out there in your environment, but lead is right where you live, right where children live, and it's a huge issue. So let's skip ahead to page 11. This might look a little bit more familiar to you. If you have not looked at page 1, you probably looked at this page a little bit more recently. It's shocking to me how many agents actually haven't read it recently either. So just a quick reminder, there is, right in the first sentence, like we said before, it must be signed before the purchase and sale agreement. As a general rule of thumb, at our office, what we do is actually withhold the purchase and sale. We will not send the purchase and sale out for signature once it's been negotiated until we've gotten this piece of paperwork back. And so we will not, it's like do not go forward, do not move any farther until this comes back. You cannot go to the purchase and sale signing unless this has already been signed. And what is this required federal lead warning statement at the bottom of the page here? Or right here in the second paragraph, I should say. This is a lot like the same type of thing that would be on the pack of cigarettes or something like that. What is it? Well, paraphrasing really quickly, it is the reminder that every purchaser of any interest in residential property that was built before 1978 is notified that such property may present exposure to lead from lead-based paint and may place young children at risk of developing lead poisoning. Lead poisoning in young children, and this is the really important part, may produce permanent neurological damage, including learning disabilities, reduced intelligence quotient, behavioral problems, and impaired memory. Lead poisoning also poses a particular risk to pregnant women. The seller of any interest in residential property is required to provide the buyer with any information on lead-based paint hazards from risk assessments or inspections in the seller's possession and notify the buyer of any known lead-based paint hazards. A risk assessment or inspection for possible lead-based paint hazards is recommended, and is a very strong recommendation that you get it tested if you're buying a residential property built before 1978. Down here, this probably also look relatively familiar to you as a veteran agent renewing your license. It's interesting that unless you've probably gone to the extent of actually de-leading, most sellers declare that they have no knowledge of any lead-based paint and that they have no reports. So predominantly people check A2 and B2, but check with your seller before you fill out this paperwork in case they do have known lead-based paint or have provided the purchaser with any documents. You need to actually check with your seller. Maybe they do have a risk assessment or a letter of control or a letter of compliance. Just don't assume that because most people pick A2 and B2, don't particularly assume that that's the case on your next property that you represent. And then down here, you're going to select, in most cases, have the buyer initial E. They're also going to initial F. And in most cases, also, they're going to acknowledge that they received a 10-day opportunity to inspect. Item G is for the agent representing the seller to remind the agent of their obligations, to inform the seller of their obligations under federal and state law. And item H is for the agent representing the buyer to acknowledge that they verbally informed the purchaser of the possible presence of lead paint in the property. Then pretty much underneath there, everyone signs for themselves. Let's take a look at the paperwork that you're going to use when you have a rental, a regular standard rental. The regular standard rental form or package, I should say, is actually 4 pages, and you should use the entire 4 pages. You should issue actually the first 3 to the tenant and have this portion completed by all parties. And the prior 3 pages are, for the most part, somewhat similar to the 11 pages of the original package that we spoke about, but they're tailored to rental clients, as you might imagine. So in most cases, once again, owners are going to select A2 and B2, no knowledge, no reports, but check with your client because you just don't know, especially on a case-by-case basis. Maybe you've been representing them for quite some time and you've represented them on their 10 apartments, and then you get to the 11th one, and then that's the one that's actually been de-leaded or something like that. So you got to ask it on every single rental that you represent, just not on a landlord by landlord basis, but on a unit by unit basis. And then down here below, you'll see that the tenant has opportunity to usually initial item D, because they're not going to receive most documents because the landlord's going to claim they have no knowledge or no reports. I shouldn't say claim. The landlord's going to state that. And item E, that the tenant has received the Massachusetts lead law notification, which is actually the preceding 3 pages. You're going to initial, as the agent representing the property owner, item F, that you've informed the owner of the owner's obligations under federal and state law. And then, like the other document, you're going to fill it out and sign, and everybody actually signs there. Technically, although I've never had this happen to me, technically the tenant can decline to sign this notice. And the tenant and the owner must each keep a copy of this notice on file. Plus, your agency should as well. Let's take a quick look at the vacation rental form. With the short-term vacation or rental exemption notification, I think the most important statement here is actually down at the bottom of the form, where it says, if peeling paint is present in the dwelling unit, the owner is not exempt from the obligations of the lead law. So that's very, very important. And in other words, if there's peeling paint, you can't use this form. So what does it actually say? After you fill out the street address, you're going to be faced with a choice that the property, which is being rented for vacation purposes, certifies. So if you fill this out on behalf of the property owner, you are certifying that, if you check box number 1, all paint, not some, but all paint in the dwelling unit is intact, including on the exterior parts of the windows, and qualifies for an exemption under the lead law. Or you can check box 2, which in case the dwelling unit has received a compliance document certifying that the unit meets standards for full de-leading. Now, I'm just going to throw this out to you. If you are signing this on behalf of the property owner and you have not been to the property anytime recently, I would strongly suggest that you get out to the property before you fill this out and certify that all paint in the dwelling unit is intact. I think that would be a strong point of practice. So keep that in mind. You do have the opportunity to sign this on behalf of the property owner, as you can see here, and they're going to ask you the date of the visual inspection. This form, of course, should never be used for any type of rental that exceeds 31 days. So most of your vacation rentals are for a week or 2, and you can use that to be fine. Or some people actually might even rent a cottage for a month, but anything more than 31 days, you cannot use this form. We're going to link all 3 of these forms up underneath the video in case you want to download them. They're probably already available to you through your office. You can get them through the State Department of Public Health, but we'll link them here for you as well. My name is Jack Gately from Jack Gately Real Estate in the Online Real Estate Academy. Thanks for watching.